Remember, temporary restraining orders, preliminary injunctions, by definition, by statute, are literally, this is how they're described, extraordinary remedies. They are not normally granted. They are extraordinary. But they have been raining from the heavens like dead frogs in India when it comes to Trump. All is fair in love and war against Donald J. Trump. Preliminary injunctions here, temporary restraining orders there, again and again and again. That, it is the malfeasance of the Article 3 federal judiciary that is driving these cases to the emergency docket. The fault is with the corrupt and insubordinate judges. The Court of Appeals opinion, with Millett and Pillard voting to support Judge Ali Khan's injunction ordering Trump to rehire Rebecca Slaughter to delegate his executive authority against his will. And Rao was the dissent. Again, that was the case linked in the description that I covered September 3rd. I'm not going to read the whole thing again. I just wanted to point out to everyone how thoroughly, so I didn't spend much time on the majority because I knew it was going to be trash, but the dissent from Rao, I knew would be a roadmap for the Supreme Court to follow. And it starts here on page 15, goes to page 29. So 14 pages of dissent, about half of this decision. 14 pages of dissent. Look at the density of value. You can tell by the red lines and the arrows and the check marks, all that. This is the compelling argument by Rao in the dissent. When we look at today's ruling from the Supreme Court, they don't provide a lot of context. They basically give a one-paragraph statement saying that we are staying the order to Trump to give Rebecca Slaughter her job back. And there's been a lot of criticism from the left, given Trump's 19-0 record, that the Supreme Court's not giving enough detail on their reasoning here. You saw the 14 pages of Rao's argument why Rebecca Slaughter should not be given her job back with an injunction by an unelected black-robed tyrannical inferior district trial court judge. Anyone wondering what's behind the one-paragraph order supporting Trump? The argument the Supreme Court heard was that argument from Rao, that 14 pages. The reason they arrived at this conclusion was that argument. There we are. All right, let me pull this up, get my red pen. All right, Donald Trump versus Rebecca Slaughter. Rebecca Slaughter, how's that working? Okay. The application for a stay. So the stay is a freezing of Judge Ali Khan's order that Trump had to reinstate Rebecca Slaughter back to the Fair Trade Commission against his will. Delegate his executive authority against his will. The application for a freezing of that order to our president by that judge, an unelected black-robed tyrannical inferior district trial court Judge Ali Khan, presented to the Chief Justice and by him referred to the entirety of the Supreme Court, is granted. The stay is granted. Spoiler right there in the first sentence, Trump wins. The July 17th order of the United States District Court for the District of Columbia, that's Judge Ali Khan, is stayed, in case there was any confusion. The application is also treated as a petition for a writ of certiorari before judgment. In other words, the Supreme Court is going to take the case away from Judge Ali Khan. The normal practice here would be for a preliminary injunction. If it gets stayed by the Supreme Court, then the Supreme Court would send the case back to the trial court for adjudication on the merits, for a full-blown trial. Because the Supreme Court doesn't want to be a trial court. You don't get promoted all the way to the Supreme Court so you can do trial court work. That's what trial courts are for. So normally what would happen is the Supreme Court would just decide the preliminary injunction issue and then send it back to Judge Ali Khan. Here they're saying the petition for certiorari before judgment under Ali Khan is granted. What does that tell me? That tells me they don't trust Ali Khan to handle this matter. They think her conduct, her decision-making, and granting this preliminary injunction after the Supreme Court had reversed the orders reinstating Gwynne Wilcox and Kathy Harris is so outrageous. Such an act of open rebellion and insubordination by a federal trial court judge, Ali Khan, against the authority of the Supreme Court, that they are taking the case away from her. And it's about damn time. The parties, Trump and Rebecca Slaughter, are directed to brief and argue the following questions. This is what the Supreme Court wants to hear argument on. Whether the statutory removal protections for members of the FTC violate the separation of powers, And if so, whether Humphrey's executor should be overruled. Well, they clearly violate the separation of powers. And if you believe that, because the exercise of the executive authority is the core and plenary power of the Article 2 executive branch president, except as the Constitution limits that authority. Congress does not have the authority to further limit the executive. That's why there's a separation of powers. Any more than the president gets to tell Congress when they're in session or how to vote on bills or whether they should have a filibuster. Those are decisions the Article 1 legislative branch makes for itself in its own house. How the president exercises his executive authority, unless constrained by the Constitution itself, is not up to Congress. It's not up to the courts. So obviously, these congressionally created removal protections are an intrusion on the Article 2 executive power by the Article 1 legislative branch. That is a separation of powers violation. And if you believe that, and only a partisan could not believe that, then it's clearly necessary that Humphrey's executor, which is dependent upon that violation of the Separation of Powers Act, must be reversed. But even if it's not reversed, the proper understanding of Humphrey's is that if you're wrongfully terminated, your reward, your remedy, is you get back pay. Neither Humphrey's executor nor Weiner nor Humphrey's Weiner ordered the president to delegate his executive authority against his will and give that person their executive branch job back. That's not what those cases hold. So that's the first question. Number one, numero uno. Second, whether a federal court may prevent a person's removal from public office either through relief at equity or at law. Can these federal judges keep issuing these injunctions against the president for firing people? That would be a nice question to settle, wouldn't it? Because so far, every time it's happened, Gwynne Wilcox, Kathy Harris, Hampton Dellinger of the Country Club Dellingers, and now Rebecca Slaughter, the Supreme Court has to interrupt its normal course of business and hear these appeals on the emergency docket. I think they're getting sick and tired of it. The clerk of the Supreme Court is directed to establish a briefing schedule. So this is going to be like a trial before the Supreme Court that will allow the case to be argued in December 2025. So a few months from now, the stay shall terminate upon sending down of the judgment of the court. So when the Supreme Court issues a final decision on the merits, you won't need this stay of the preliminary injunction. That won't be in effect anymore. So that's one paragraph. The liberals hate this. They say, but we don't know why. We don't know the rationale of how the Supreme Court came to this decision. Yes, you do, you dirty little liars. You know exactly how the Supreme Court came to this decision because there was a dissent from the Court of Appeals, a 14-page dissent, laying out why Rebecca Slaughter and Judge Ali Khan's decision was wrong. And then John Sauer, the Solicitor General of the White House, has argued at length. We covered that argument too to the Supreme Court why Rebecca Slaughter and Judge Ali Khan's preliminary injunction is wrong. There's literally dozens of pages of argument on this, all of which has been presented to the U.S. Supreme Court. That's how they got to this paragraph. It's insane. It's like getting handed a cake for dessert at a restaurant, and you're like, well, we don't know how that cake was created. Yes, you do. I mean, you saw the recipe, ingredients come from the supermarket. There's no mystery here. It's not like you found a cake on the street. All right, now we get to the dissent. The usual, the three crones in the dissent. Justice, Elena, no, I've never been married, never had kids. Why do you ask? Kagan, Justice, the wise Latino, the Latini with the diabetes. Justice Sonia, the wise Latina Sotomayor. And Justice Ketanji. No, I'm not a biologist. How would I know what a woman is, Jackson? I mean, she could just lift her skirt. I guess not. They dissented, the usual three, 6-3 decision again. This time, Kagan is writing. Previously, there may be one other dissent in the other 18 wins for Trump. There may be one other where Kagan wrote the dissent. I'm not sure. Most of the time, it's been Sotomayor and Jackson writing the dissents, and Kagan joins or doesn't join, depending on her mood that day. All right, Kagan writes, on top of granting certiorari before judgment in this case, in other words, in addition to taking this case away from the unelected black-robed tyrannical inferior district trial court judge Ali Khan, the Supreme Court today issues a stay enabling the president to immediately discharge without any cause a member of the Federal Trade Commission. You know what? Hey, Kagan, that's a feature. That's a feature, not a glitch. Not a glitch. But Kagan doesn't like it. That stay granted on our emergency docket is just the latest in a series of stays in firing cases. So what Kagan wants is she doesn't even want to hear about this case until Judge Ali Khan has decided the merits in a final adjudication months or years from now, during which time, of course, if Kagan had her way, Rebecca Slaughter would be an insubordinate commissioner on the Federal Trade Commission working against Trump's agenda for the entire time. Also, she doesn't like that this is not the first time the Supreme Court has ruled in favor of Trump in a firing case, as we've already covered. Earlier this year, Kagan writes, the same majority, the same 6, by the same mechanism, permitted the president to fire without cause members of the National Labor Relations Board, the Merit Systems Protection Board, and the Consumer Product Commission. Congress, Kagan writes, as everyone agrees, prohibited each of the presidential removals. Yeah, I agree. Congress prohibited it. The question is, do they have the authority to prohibit the president from firing someone? The question isn't why does she even say that? As everyone agrees. What difference does it make? This is not the legal question, whether everyone agrees on whether Congress said you can't. The question is, does Congress have the authority to say you can't? Under the relevant statutes, again, that's just Congress saying something. Congress could say the president doesn't have the right to pardon anybody whose last name begins with the letter A. They're not allowed to limit the president's pardon power, just like they're not allowed to limit the president's firing of executive branch personnel. But Kagan writes, under the relevant statutes, the independent agencies are classic independent agencies, multi-member bipartisan commissions whose members serve staggered terms and cannot be removed except for good reason. Now, it always makes me laugh when I see the losing side of a Supreme Court fight with Trump, and it's always some combination of these 3 women, Kagan, Sotomayor, and Ketanji Jackson. It always makes me laugh because whenever they're writing in dissent and they start quoting other cases like an authority, first of all, they quote dissents. So in their losing argument, this is the dissent, right? It's the losing argument. In their losing argument, they not only quote some other losing argument, another dissent, often it's their own dissent. Kagan here is quoting as authority for her dissent, her losing opinion, her losing argument by herself in another case. Kagan cites Kagan. Kagan in dissent cites Kagan in dissent. You can't make this shit up. Yet the majority, the winners, the 6-3, stay order by order, has handed full control of all those agencies to the president. Who should have control of executive branch agencies? Does Congress have executive authority? No. Does the Article 3 judicial branch have executive authority? No. So when agencies are doing things, executing the law, who's supposed to have authority over them? Nobody? Nobody? That's not what our Constitution says. The Constitution says the president does. Kagan continues, the president may now remove, so says the majority, though Congress says differently, any member he wishes for any reason or no reason at all. Yeah, that's right. That's what the Constitution says. Congress doesn't have the authority to say otherwise. And the president may thereby extinguish the agency's bipartisanship and independence. Again, these agencies have no legitimate independence. Independence for any political entity, independent from the political will of the American people, is tyranny. Political authority without accountability is tyranny. Kagan writes, I dissented from the majority's prior stay orders. I was on the wrong side before, and I'm on the wrong side again. Under existing law, what law? The unconstitutional law of Humphreys-Wiener? Under existing law, what Congress said goes. As this court unanimously decided nearly a century ago in Humphreys-Wiener, Humphrey's executor, 1935, we rejected a claim of presidential prerogative identical to the one made in this case. They did. They said Humphreys was fired wrongfully. It was a wrongful termination. But remember, there's the offense and there's the remedy. The offense was wrongful termination. What was the remedy? Money. Money. Not a forced delegation of executive authority against the president's will. If Rebecca Slaughter here simply asked for money, she'd probably get it. Trump doesn't give a shit if she gets paid back wages. He just does not want her exercising the executive authority that the Constitution grants only to him as the elected Article 2 president of our great United States. And then Kagan notes that Humphreys, from Humphrey's executor, was head of the FTC, just like Rebecca Slaughter is head of the FTC here. In Humphreys, we held that the Congress may restrict the president's power to remove members of the FTC, so the president cannot, as he conceitedly did here, fire an FTC commissioner without any reason. According to Humphreys, which is unconstitutional, and even then, the remedy is money, not the forced delegation of executive authority, which is what Rebecca Slaughter is asking for here, and what Judge Ali Khan granted her, and what the Court of Appeals granted. That Judge Ali Khan, an unelected black-robe, tyrannical inferior district trial court judge, supposedly has the authority under the U.S. Constitution to order the elected Article 2 president around like he was a clerk in her court. You will exercise your executive authority as I tell you to. Delegate your executive authority as I tell you to. What do you think you are, the president? I'm a judge. They gave me a robe and everything. Kagan writes, to reach a different conclusion requires reversing the rules stated in Humphreys. Actually, no. If you applied Humphreys' executor correctly here, you could say Trump fired her wrongfully and she's entitled to money. That's all Humphreys did. But Kagan says it entails overriding rather than accepting Congress's judgment about agency design. Congress doesn't get to decide how the president exercises his core and plenary powers. Kagan writes, the majority may be raring to take that action, as its grant of certiorari before judgment in this case suggests, but until the deed is done, Humphreys controls. Again, even if Humphreys controls, all it allows for as a remedy is money, not forced delegation of executive authority, and prevents the majority from giving the president the unlimited removal power Congress denied him. Congress does not have that authority. The Constitution would have that authority, but the Constitution doesn't say that. By the way, the Constitution does limit the president's ability to delegate executive authority. For principal officers of the United States, like cabinet members, the president has to get the advice and consent of the Senate. His ability to delegate authority is limited by the Constitution. His ability to terminate that delegation is not. I'm going to get to the super chats and stuff in just a minute. Thank you, though, for the very kind comment. As soon as I'm done here. She continues, because the majority's stay does just that, I respectfully dissent. Our emergency docket should never be used, as it has been this year, to permit what our own precedent bars. Kagan doesn't like that Trump has been successful in appealing to the Supreme Court on the emergency docket 19 times for wins, 0 times for losses. Why is the emergency docket being used in this bizarre way? Because we have a couple of dozen unelected black-robe tyrannical inferior district trial court judges from a handful of federal districts in open rebellion and insubordination against our constitutional order and against the Supreme Court itself. That's why Trump has to keep going to the emergency docket. If these unelected black-robe tyrannical inferior district trial court judges were not issuing these preliminary injunctions in the first place, there would be no rushing to the emergency docket. Remember, temporary restraining orders, preliminary injunctions, by definition, by statute, are literally, this is how they're described, extraordinary remedies. They are not normally granted. They are extraordinary. But they have been raining from the heavens like dead frogs in India when it comes to Trump. All is fair in love and war against Donald J. Trump. Preliminary injunctions here, temporary restraining orders there, again and again and again. That, it is the malfeasance of the Article 3 federal judiciary that is driving these cases to the emergency docket. The fault is with the corrupt and insubordinate judges. The fault is not with the Article 2 president seeking to simply exercise his authority, as the Constitution says. He is not only allowed to exercise it, but has a constitutional duty to do so, to see that the laws are faithfully executed. He swore that oath on January 20th, 2025, as every president swears it. So it's not a whim. You take the job of president, you don't just get to say, Congress, the courts, they're being a hassle. I'm just going to let them do it their way. No. Sadly, too many presidents have. But the great and powerful President Donald J. Trump has got balls. This president has balls. Kagan concludes, still more, the emergency docket should not be used, as it has been, to transfer governmental authority from Congress to the president and thus reshape the nation's separation of powers. Congress seized for itself authority the Constitution does not grant it. If Congress is losing unconstitutional authority, that is all to the good for our constitutional order. That's not a reshaping of the separation of powers. You know what it is? It is a restoration of the separation of powers, which you would think a Supreme Court justice would be all for.